Welcome, everybody. Thanks for being here. We're having a little bit of technical difficulties. I hope everybody can hear me. Let's see, we have to admit anybody. Angela was there. Sorry, it was a little funky. There we are. We're back. I'm having a little issue with getting in and out of my system for some reason today. Well, we have 64 people on, and it's nice to see everybody. It's finally kind of nice out. We're getting some nice warm weather, still a little overcast though. Like threatening rain, not really raining or anything, but kind of threatening rain. It's been drizzling on and off. Nice to see everyone. Brenda, I haven't seen you in a million years. Nice to see you. Nice to see everyone. Mike Polulak is with me today. We just came back from CAI, the Community Associations Institute National Trade Show and Conference. This is not the law seminar. This is a trade show and conference where they have a trade show. It was in Orlando, mainly management and manager training. We are down there, and we basically saw everyone was down there. There was a New Jersey contingent. Thought I saw Mr. Magid. Mr. Magid was down there. Hi, Jim, and a number of other senior New Jersey managers and other managers who were getting training and or receiving their certification. So generally speaking, at the CAA National Conference, the managers are awarded their designations. And as I spoke with Jim down at the conference, probably next month, Jim and I are going to do a little joint Friday with Fran. Hopefully Jim can make it. And we're going to talk about manager education, manager designations, what the manager designations mean, what the managers get out of that training. So we're probably going to do that next month. Today, I have to read my little disclaimer like I always do, which is annoying. But these webinars are provided for general informational discussion purposes only. These webinars do not and cannot form an attorney-client relationship. We know that. The information exchange does not constitute legal advice, even though it might sound like legal advice. You have to go out and get legal advice from your own attorney or us, if we're your attorney, and we'll tell you with respect to the particular facts. You have to enter into a written retainer agreement with your attorney before you'll have an actual attorney-client relationship with them. You have to present your particular facts. No information discussed during the webinar will be kept confidential. We do have a dog of the day today. Let's see. Crystal, if you could pop the dog of the day up there today. And you got to see this dog. Look at that dog. My God, right? I mean, so this dog's name is Wyatt. Wyatt, he's I don't know what kind of breed it is. Mike might know what kind of breed. I think he looked it up before.
I think it's like a Vizsla, Vizsla is what it looks like. Rob can tell us.
Okay, so, but beautiful dog. And, probably just important as the dog, I hate to say this, is the photography and the architecture in Rob Thomas's home. So this is Rob Thomas's dog, Wyatt. Rob's with Comet Management. And what a beautiful home. What a beautiful dog, and what beautiful photography. I first looked at it and I thought, this is not Rob's real dog. He actually ripped a page out of Architectural Digest. But it is a beautiful dog. I think it's a real dog with a real house. And I think we'll be putting Wyatt in the 2023 calendar. So thanks so much, Rob, for sending Wyatt's picture in. And Crystal, will rock and roll. As an intro, so Mike is going to talk a little bit about some new developments in the COVID, non-COVID world vis-a-vis the swimming pool issue. And then I'm going to jump into the agenda items regarding New Jersey Association laws, and can I read them myself? So Mike, you want to go with the intro there?
Yeah, sure. Thanks, Fran. So believe it or not, everybody, the New Jersey Department of Health actually updated their guidelines, and it's wonderful. So I'll read what it says. It's a brief paragraph. It says, public recreational bathing, which is association pools, falls under that. Facilities are not required to implement any COVID-19 mitigation measures for the 2022 bathing season. Woohoo! Facilities may choose to implement measures if they so choose. And it just says the CDC indicates that there is no evidence that the virus that causes COVID-19 can be spread to people through swimming pools, hot tubs, splash pads, or fresh and marine water. So that's it. So they actually updated their site. Their recommendation now is to proceed with whatever seems reasonable under the circumstances, but they are not requiring any mitigation measures. So That's a big win for everybody. And that was updated on Monday on the recreational bathing code from the New Jersey Department of Health. That's it.
All right, Mike, you want to say a word also about the craziness some of these pool vendors are
Oh, yeah.
about
So
with the indemnification, defense, and hold harmless.
So, yeah, as you'll probably see this year, so we've been speaking to pool vendors who are forewarning us that this year may be similar to last year in finding people to work as lifeguards, as assistants. So prepare yourself. It might be another nightmare disaster season. They are oftentimes trying to push through really crazy language in their proposals. And some of the companies are giving a lot of pushback. And in particular, what Fran just mentioned is the hot topic. It's indemnification. They want the association to indemnify and hold the company harmless in the event that there's an issue, which is insane. Under no circumstances would an association hold a vendor harmless for negligence or reckless behavior. So please ensure that your attorney reviews the proposal from the company. Keep in mind, if you sign a proposal, that creates a binding contract. Sometimes the proposal comes to us and it's already been signed. So we have to try to work with the vendor through our relationships with them and try to back out of it, and then put together a contract that is going to be mutually acceptable. So just be forewarned that this may be a challenging year, and the pool vendors are becoming more and more aggressive with some of the language that they're using in their contracts.
All right, thanks so much, Mike. And just so you know, if you see Mike disappear, he has a meeting with a board president today, so he's not just blowing you off. He actually has a board president coming into our brick office to deal with some documentation. So thanks, Mike, and we still have some people popping in, which is great. So I'm going to go back to the agenda. So governing documents, we don't, New Jersey Association laws, can I read them myself? The answer is yes, you can, right? You can read them yourself. The beginning place for, I would say, any community association member or a board member or a manager or a service provider that is looking for some guidance is obviously your governing documents, right? So your governing documents, and we've talked about this a lot, and we have a little bit of a low turnout today. I'm hoping 67 people. That's still fantastic, but we usually get a little bit more. It may be that the topic is not as riveting as it could be, but this is a really important topic, and I hope you get something out of it. So the governing documents, the way I look at governing documents, you know this, most of you who attend regularly, master deeds should govern property rights. Bylaws should govern how a corporation functions. That's why you have two sets of documents. You should keep that in mind all the time. As a thumbnail way of looking at it, master deed or declarations in the case of homeowners associations govern property rights. Bylaws govern how the corporation runs. The unfortunate thing is a lot of developer attorneys, as good as they may be, tend to conflate those concepts, and they put property rights in the bylaws and corporate governance in the master deed or declaration, and that messes everything up. So the good news is it provides a lot of work for us, me and Mike, to try and straighten that out and interpret them, which is really bad for associations. But as you know, many of the associations that are represented online today, we have tried to straighten those things out over the past couple of years via Radburn amendments that make it much easier to do that, and honestly, much cheaper to do that. So if you do have continuing issues with your governing documents and that you can do bullet point amendments, do them via Radburn amendments if you can, because it's pretty quick and pretty cheap, and it will clarify some of those issues. But getting past the governing documents, and this is not an advertisement for the GAN company, GANN, not an advertisement for the GAN company, but many times people ask me when I go to board meetings, hey, Fran, where can I see all the laws? I went to the New Jersey legislative website and they have all these statutes in there and bills and laws and amendments, and it's just chaos. I can't find anything. And you talk about Radburn, Fran McGovern, and I look on the internet, and there are articles by various association attorneys and websites and stuff, but it all seems chopped up, and I can never get to the law itself. It's so annoying. I want to smash my head against the table, right? So there are a lot of people who feel that way. I need a good resource. And the good news is we have a wonderful, wonderful resource for this in New Jersey, unlike most other states. And that's the Gann Treatise, Gann, the Gann Treatise on Condominium and Community Association Law that was originally written by Wendell Smith. I don't know if you remember Wendell Smith, he's retired now, from Greenbaum Row. Wendell is kind of the dean of the industry in New Jersey. He's a legend in his own time. He's still with us. And he was one of the early attorneys for the Levitts, if you will, the Levitt family who were involved in building the Levittowns, right? And in Pennsylvania, as well as New York. And for those of you who are from New Jersey, you may forget that Willingboro, New Jersey, was actually a Levittown that was renamed Willingboro. So he was a legend in terms of planned developments like associations. He grew out of that, went to Greenbaum, and now Christine Lee, who is also an attorney there, and Dennis Estes, who is also an attorney at Greenbaum, mainly on the developer side of things, I must say, but notwithstanding the fact that I disagree with Wendell, Dennis, and Christine on many issues involving developers and how their clients conduct themselves vis-a-vis associations. As you know, we don't represent developers, we just represent associations. It is still an excellent treatise, but more importantly, it has a fantastic set of appendices. And that's what I'm going to talk about today, the appendices. And people say, Fran, what do you mean appendices? Last time I looked at the index in front of a book, it gave me a headache. The good news is the appendices in the Gann Treatise lay out things cleanly. I'm going to share screen just so you can see it. I would encourage, and I'm not trying to take work away from myself, I would encourage every association to buy at least one Gann book. You still need professional management advice, you still need professional legal advice, but and I like I said last time, I don't want this book to be used as a stump the lawyer thing, right? So play lawyer trivia. Hey, Fran, what do you think the Planned Real Estate Development Act really means at Section 5, right? And you have the Gann book in front of you and you're looking at Section 5. So that's not the purpose of this, but it's a very good thing, I think, to help educate board members and managers. So the annoying thing for some association members, and by the way, I believe that if the association is going to go out and get this book, do it, number one, in the hard copy, right? That's it right there. There's an example of it. That's the hard copy. It's a different color every year. That's the Gann book. But you can also, and you should with your license, get an online version. What I'm going to be showing you today and talking about is the online version. Hopefully, for some reason, they've bounced me out about 4 times as I was preparing for today's session. Hopefully I don't get bounced. So if we go to a screen share, let's see. Let me go to a screen share, if you just bear with me for 1 second, and I'm going to try to pull up the Gann website. They have a nice website. It's a little boring, but that's okay. We're not going on the website for excitement. As you may or may not know, there are plenty of websites out there that are all kinds of exciting things, and people jumping off buildings, people taking their clothes off, people doing wacky things. That's not the Gann website. Gann website, real boring, but very important, informative. All right, so let's see. I think I got it. All right, can you see the website? Are you good there? Do we have a nod? Yeah, okay, so we're good. So this is the Gann website, and I have a license, so I have the ability to pull up the Gann website and talk about it and walk you through it today. Like I said, what is annoying to many associations is the cost. The cost of the book in hard copy and the license for the website is $211 per year. This book comes out annually, and I think it is money well spent. I have no interest in Gann. I consider Dennis Estes and Christine Lee and Wendell Smith colleagues, and I have a very good relationship with them. But even though we're oftentimes on opposite sides of the developer issue, but I'm not endorsing their opinions, but I'm saying this is a great resource. So on the left here, if you can see, okay, it's really fine print, so annoying, but it is fine print. So they're just going part 1, fundamental concepts, okay? Structuring and financing. Now you can see that Greenbaum basically comes from the developer's perspective. This is more or less a handbook for creating community associations, right? Fundamental concepts, structuring and financing. the governing documents, master deed, certificate of incorporation, et cetera, the bylaws. Marketing the condominium, that's how you sell it. Why is that a very dangerous thing for developers? Is if they make representations, they're bound by it. So when you're marketing and selling condominium units or homeowners association interests, you have to be very careful what you disclose, what you say to the public. Conveying the unit, that's actually selling the unit. Condominium conversions, for those of you who may live in North Jersey, that's fairly common in North Jersey, where you have former apartment complexes that are converted into condominium associations and the units are sold off. You also see that a fair amount at the Jersey Shore. Projects in distress, again, they're coming from the developer side of things. Litigation in the community association context. Specialized concerns, that's actually purchasing the units, and commercial units that we don't really need to talk about that today. The governance is transition from the developer to the association, collecting the assessments, et cetera, enforcing restrictions. So it's nice. So all those parts are the treatise, which more or less involves the author's opinions overlaid on those various issues, which again, many of those issues are subject to fair debate. Where I want to go with you today is if we go to the very bottom, when we talk about, can I read the law myself, right? You want to go to the very bottom of this online and go to the appendices. We click on appendices. There it is. The appendices, Franco, this is nuts. There are 40 appendices, 40 appendices. Now, again, much of this comes from the developer perspective, so much of this you don't need. I'm just going to talk about some of the things that are very important for you if you want to take a peek at them very easily. And rather than going for places like the New Jersey legislator's website or going through some law firms, online articles or et cetera. Again, I'm not disparaging associations' online websites. I have an online website. I like it. But this is just a very good presentation of the actual law itself. Again, keep in mind, it gets updated every year because laws change. So be careful with that. So some people go, oh my gosh, I have the GAN law book from 2017 or from 2015. Not good, not good. You want the current one because things change and the case law reference changes. So if we're looking at the appendices, the first thing we see is the Condo Act. That's important to you, most of you, right? The Condo Act, if you're involved in condo world. The Cooperative Recording Act, that's as to co-ops. We have very few co-ops. We probably represent 10 of them maybe. Some of you may be in co-ops, but I don't think many of you are. That's the Cooperative Recording Act. The Planned Real Estate Development Full Disclosure Act. What is that, Fran McGovern? The Planned Real Estate Development Full Disclosure Act. Lawyers refer to that as PREDFA. PREDFA. Let's click on that a second. I'll enlarge it a little bit. So annoying, right? There we go. So this is the Planned Real Estate Development Full Disclosure Act. And this is where a lot of people are confused with this thing called the Radburn Act. The Radburn Act, the Radburn Law of 2017, right? They say, hey, Fran McGovern, where's the darn Radburn Law? I go online, I can't find it anywhere. The Radburn Law is not really, even though it was passed as a freestanding bill, right, is not really a freestanding law because really what it is an amendment to the Planned Real Estate Development Full Disclosure Act, or PREDFA. So many board members say, Fran, I can't find Radburn. The Radburn law, it's nowhere. Here it is. This is Radburn, because what Radburn did in 2017 was amend about, I would say, 8 or 9 major sections of the Planned Real Estate Development Full Disclosure Act, much of it relating to meeting notices, elections, etc. So I hope that makes sense to you, that if you want to think about Radburn, think about this provision. So it's Appendix 3 in the GAN book that will show everything from the Radburn law incorporated. Okay, so that makes a lot of sense. A lot of people don't realize that Radburn was a law, freestanding law, but it really is an amendment to the PREDFA law. Okay, so let's go back for 1 second. Okay, so then the Planned Real Estate Development Full Disclosure Act we talked about, that is Radburn. Radburn is in there. Radburn was engrafted onto that and made changes to PREDFA. Same thing, regulations adopted under the Planned Real Estate Development Full Disclosure Act. That was in, I think, what, 2022? I'm sorry, 2020. Radburn amended the regulations under PREDFA. So again, in the appendix number 3B, we see, let's see. There we go. So people go, Fran, where are those Radburn regulations? I don't see anything in that GAN book that you say is so wonderful. This says there's no appendix that says, here's the Radburn law. And again, the Radburn law is an amendment to the Planned Real Estate Development Full Disclosure Act law. The Radburn regulations are amendments to the Planned Real Estate Development Full Disclosure regulations that are passed by an administrative body. So again, if you're thinking about, hey, Fran, where are the Radburn regulations? They are incorporated as changes to the Radburn, to the Planned Real Estate Development Full Disclosure regulations. And just so you know, and Jim is well aware of this from being on LAC, this is where we feel, I think the consensus in the community association world is that the state's administrative body in adopting these regulations overstepped their authority under the original Radburn law and just started making things up, right? They went beyond their authority under the law itself. And I'll click back in a second. Let's see, Chip Hoover's here. Yeah, so somebody didn't. So Chip, you're in now. Nice to see you. So we don't have to worry about Residential Tenant Protection Act. We don't care about that stuff. What else do we think about when we look at the appendices here? Corporations, the Nonprofit Corporations Act, right? Nonprofit Corporations Act. Associations are typically nonprofit corporations. So if we're thinking about whether or not an association has power to do things, whether they're prohibited from doing things, we have to not only look at PREDFA, not only look at the Condominium Act and the regulations, we also have to look at the Nonprofit Corporations Act, because that may impact an association's power to do certain things. So that's a nice resource to have the Nonprofit Corporations Act there. If we take a little bit further down, I'll give you an example, and this is a nice example that many developers that the Greenbaum firms work with incorporate into their original public offering statement. If you don't have this in your original public offering statement, I think it's a nice thing for the association to do, even though it might be a little bit expensive, to incorporate via an amendment or a rule and regulation resolution so that it makes things a little more clear to your residents. Let's see. Schedule of maintenance responsibility. So that's Appendix 22. So we don't need the verbiage in much. I just want to give you an example. So general common elements, blah, blah, blah. This is where things get nice if Greenbaum's clients incorporate this into their public offering statements. It's an actual schedule of who's responsible for what, right? So items, plumbing, general common element, limited common element. Whose responsibility for the association, who's responsible as the unit owner. Get a nice spreadsheet, right? So Appendix 22, this is just an example. This obviously does not apply to every association. It's just a sample. But again, this is Appendix 22 in the GAN book or in the GAN online. It gives you a really good idea that if the association wants to lay things out like this, who's responsible for what, it's a very nice reference for your member population, because obviously members generally don't like reading language like this, you know, a bunch of verbiage, blah, blah, blah. How do we translate that into plain English, Fran McGovern? And a good way to do it is a spreadsheet like this, which is nice. That's Appendix 22 as an example. So I brought that up for you. There are examples also in the appendix here. I don't want to take this too long today. There are also examples of things like architectural control guidelines, just samples. Nice sample, right? Architectural control, antennas, additions, attic fans, blah, blah, blah. Now, obviously, working with us or your own attorneys, you'll have to customize this, but it's a very good starting point for discussion with your attorney. You say, hey, you know, I had the GAN book. I was looking at solar collectors, for example, and I noticed in the GAN book that it says blah, 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 blah. Can we do that as well? Should we do that? Let's think about that. What about equipment for children? What about lighting? What about parking? Things like that. So it's a helpful starting point, right? If nothing else, it gives you ideas for discussing things with your association attorney and with your management representative. Same thing, resolution process. It's a discussion of the resolution process itself. Again, I'm not going to agree with everything that is in this book, but it's a nice starting point for discussion, right? Gives you an example of various committees, examples of a policy resolution handbook, etc., and how resolutions are adopted. So very helpful for those who are not used to or not experienced in the community association process, especially those who are new to the board or new to management. I'm going to keep going down. What another thing is very important for all of us is the Municipal Services Act. For those of you who don't know, the Municipal Services Act, which is also referred to as the Kelly Bill, same law, not two different laws. Kelly Bill, Municipal Services Act, same thing, says that a municipality must either provide this services provided by the town to non-association residents in the community or reimburse them for what it would have cost the municipality to provide those services. And those services are generally limited to garbage and waste removal, snow removal, and other obstructions in the street. So some towns provide recycling, and then also street lighting on the same basis as the town would provide it to public roads. The key thing to keep in mind about street lighting is the town only has to reimburse you for the electricity portion of your street lighting, not the depreciation or the cost of the fixtures, poles, etc. Anyway, there's an example of the Municipal Services Act in there. So many times people say to me, Fran, where can I find easily the Municipal Services Act? In the appendices. Okay, very helpful. Municipal Services Act. There are examples in here, I'm not going to go into them, of meetings of the governing boards of associations, management. There's a sample management agreement there for discussion purposes. Again, these things with respect to meetings, management agreements, etc., they're all over the board. The GAN book is basically just giving examples of items. Additional topics are articles for example, access to records of associations, accounting standards in associations. And again, these portions are opinions written by professionals in the field. It may not be subject to universal agreement. So this, for example, is written by Carol Karansky. For those of you who know her, Carol is a very nice person, very knowledgeable. And she's an accountant at Wilkin and Gutton Plan. And she's giving a whole background. It's a nice article by Carol on her feelings as far as the CIRA background, accounting methodologies, et cetera, right? So it gives you a nice background, how we got to accounting standards in association world, et cetera. So that's a nice overview by Carol. I'm not certain, but for some reason, I think Carol may have retired as well. Everyone's retired. Where are all the kids going? I don't know. So compliance with Housing for Older Persons Act. For many of you online with me today, people say, I hear there's some kind of compliance thing. What do we have to do? So if you look at the Appendix 38, there it is. It's an example of a form that can be used when someone moves into an active adult community that says, I'm buying in here. I understand that this community is subject to HOPA, which is the Housing for Older Persons Act, and I will provide proof of age. Right? These are the residents, here's our age, this is birth, who's living here, so that the association can prove that it meets the safe harbor under HOPA for age discrimination exemptions. Okay, so that's just an example. Nice example though, right? Makes it nice and simple. There's an article by Mitch, for those of you who know Mitch Frumpkin. Again, I use Mitch as an expert, but I don't always agree with him. So this is Mitch's opinion regarding reserve studies, et cetera. It's a nice article overview on reserve studies and examples of reserve studies by KIPCON. As you know, Mitch is a very bright guy, very experienced in the field. But so that gives background on reserve studies. So I believe in many respects, the appendices of the GAN book, whether it's a hard copy or online, are more important than the actual text of the book itself. The text is good. I read the text too. Like I said, I don't agree with everything in there. But I find the appendices more important because it's one-stop shopping for a source of law. If you as a board member, you as a property manager say, hey, you know, I heard what Fran McGovern says, or I heard what Mike Palulek says, or I heard what Pat McGlone says. or Damon Kress. And I would just like to take a read of that. Easy place to find the law itself. So Al D'Amato just joined us. Hi, Al. And I'm going to stop the share right now so you don't go blind, because I know that that text is a little tough to read. Stop the share. Bring you back over to my other screen. There we go. So that is a brief overview of the GAN book, and more importantly, the appendices in the GAN book, because you can use it as a touchstone or a one-stop shop for looking at many of the basic laws in community association world. And I've had some board presidents say, hey, Fran, I want you to give me a list of every law and every statute that applies in community association world. No is the answer to that, because I would have to put a library on your desk, right? Because almost all law applies in community association world. Labor law, environmental law, contamination law, personal injury law, because we live in community associations, and almost every type of law has bearing on us. You usually get to this as a last resort, but constitutional law, both state and federal constitutional law, applies very importantly in the community association context. So there is no repository for all of the law that applies in the community association context. So even though I'm saying that the GAN bulk appendix is a nice one-stop shop as a starting point for discussion with your attorneys or your managers, it's not an exhaustive resource. There are all types of other laws that have bearing on what you guys do, ladies do every day, and what we do every day. The last thing I wanted to talk about is case law. So case law, many of you online with us today know this already, but case law are the decisions of courts and administrative bodies that interpret the actual written laws or statutes or common laws. Sometimes they're published, which is nice. Sometimes they're not published, and they're much harder to find. So in many respects, published case law may be binding on the courts going forward. Oftentimes, non-published case law is not binding on judges going forward. Nevertheless, it can be very persuasive. So if I can find, and sometimes it's hard to find, like I said, an unpublished decision from a judge on the same fact scenario that I have, I will still present it to the court and say, hey, judge, this is an unpublished decision, but the facts are similar. Why don't you take a look at it? Because I think this should persuade you, Your Honor, to rule the way the association thinks it should go. Sometimes association board members are frustrated when they go to look at things like the law, and they go, Fran, the law doesn't say that. The law doesn't say what you say, Fran McGovern. And sometimes that's true, because there is case law where a judge has issued a binding decision, especially if it's the appellate court or the Supreme Court, that says, the law says this, but we're interpreting this way. And this is what we find that the law says. And until some higher court says something different, that's the way it's going to be. So some association board members are surprised when they say, hey, Fran, I interpret the law this way. And I say, that's nice. I do too. But there's this appellate division decision out there that says this is the way it's going to be. And until Fran McGovern gets appointed to the appellate division, it's going to remain that way. Or we fight it, right? We fight it. We try to make new case law. Just so you know, when your lawyer talks about making new case law and fighting things from the trial court level to the appellate division level, and God forbid, to the Supreme Court level in New Jersey, what you should hear in the background is a cash register ringing, right? Cash register ringing, because the lawyers are just piling up dollars when you litigate from the trial level to the appellate level to the Supreme Court level. It's okay if you have the money and the issue is important enough. But we advise most associations that we work with to not be involved in taking the test case up. A test case is where we want to fight to the death on an issue because it's that important to us. The problem with it is it involves significant amounts of money and many years usually of litigation, right? So be careful if you hear a lawyer say to you, you know what, let's do a test case on this. Unless that lawyer which would be very rare, says, and I will do it for free for you. Okay, because most lawyers will not do that, right? Because again, it's many, many, many hours and months and years of work, and it takes a long time, a lot of effort, and a lot of resources. The one thing to do, and Jim is aware of this too, Jim Maggot, who's with us, if you find yourself as an association in a crazy piece of litigation that you think may impact the entire industry, right? And you're like, Fran, I don't know. We wound up in the appellate division. This looks like it could not only hurt our association, it could hurt the entire community association, community in New Jersey. Reach out to CAI New Jersey, reach out to the Legislative Action Committee and other people, including myself at CAI, and talk about whether the Community Associations Institute would be interested in joining the case as what's called an amicus, and people pronounce that different ways. But sometimes organizations like the Community Association Institute and other organizations will come in at their own expense and support your case if, from a public policy standpoint, it appears important enough to push that issue through, or it appears dangerous enough to hurt the entire industry. And the Community Associations Institute in New Jersey has repeatedly become, it's not often, but in a number of cases has been involved in amicus positions for various cases. They're going up to the appellate division and or the New Jersey Supreme Court. For those of you who remember, the biggest and boldest case was probably the Twin Rivers case, which came out of Central Jersey, and the Rutgers Law Clinic was pursuing at the time. And it was very important that the Community Associations Institute and others tried to protect associations' rights that were under attack in that case. So that being said, I'm going to stop rambling. I'm at 4:43. Let's see. I do have a few comments. Somebody suggested the New Jersey Law Blog, Radburn regulations with comments. So New Jersey Law Blog. So New Jersey Law Blog, God bless them. You know, if they want to post up the text, New Jersey Law Blog. So I think the New Jersey Law Blog is, I'm not 100% sure, but I think it is, thank you for providing that. I think that is posted by one of my competitors, which is fine. The issue with that is, like I said, you have to be careful what version you're looking at. I think you should look at all resources. Like I said, though, my discussion today is not just limited to Radburn. It's to address all of those topics that are including appendices. So certainly, if you see something like a law blog by another law firm, certainly take a peek at it. It doesn't hurt. And if you have questions, certainly you can also reach out to me. But the question is it up to date? So be careful with that, right? And certainly your lawyers will advise you whether or not the section you're looking at or asking questions about is up to date. Paul says, you said the Radburn Act can be used as an inexpensive way to make bullet point amendments. Can you explain that a bit more? So many of you, we've talked about this before. It's the tacit approval amendment process for the bylaws, where the association's board votes on the bylaws, right? The board says, motion to approve this bylaw. The board says, great, we love it. And the only caveat to that is then the board has to send it out to the entire community, and that bullet point amendment may be overturned by a 10% no vote of your membership, right? That's the 10% no vote of the membership. If it's a not crazy amendment from a policy standpoint, most of them we've seen do go through, which is wonderful. Barbara says, are the appendices generally the same year to year? Generally the same, Barbara. They are generally the same year to year in terms of the number of appendices, the various topics touched upon. So yes, in terms of the same laws are there. There may be a different version of the law year to year. So for example, Radburn itself was adopted in 2017. So I believe the GAN book from 2018 incorporated the Radburn law. The Radburn regulations were adopted in 2020. They became effective in 2020. You guys may remember this. The DCA was generous to us and did it in the middle of COVID. So those Radburn regulations were adopted in the following year, right, of the GAN book. So the appendices, the numbers of the appendices are typically the same or similar, but GAN tries to adopt them as we go forward. Chip Hoover says we need to talk about Elizabeth, the Municipal Services Act. Thanks, Chip. I know Elizabeth has not been wonderful to the association. Dina says, do items in the architectural review section go into rules and regulation? So generally so, Dina. The architectural review section would go to rules and regulations. It would be passed via a resolution. In which documents do you find rules and regs? So again, they would be resolutions. Some associations, they have to be in the master deed. Sometimes they're in the bylaws. I know I'm sounding like an attorney now, but a lot of that is based on what they were originally included in. So I like to see your basic restrictions and rules and regulation in the master deed or declaration, right? Because they are property right limitations, right? Property right limitations. And if those types of rules and regulations, property right limitations are in your master deed or declaration, you have to amend those things to change them. If you just have a plain vanilla provision in your governing documents that says the association's board is free to adopt rules and regulations, then you can do that via resolution. But you can't, for example, and the classic one always is, there's a rule and regulation in the master deed that says no pets, period. And everyone says, well, Fran, we're just going to pass a resolution that says you can have dogs under 25 pounds and you can have 2 cats, but no, not 3 cats, blah, blah. No, if the declaration or master deed says no pets, no animals, you're stuck with that until you amend it, with the caveat, everyone hates this, reasonable accommodations for handicaps. So all of your master deed, governing documents, declaration, etc., are subject to rules and regulations for handicap, and also subject to law. So if your master deed, for example, the classic one has a right of first refusal, and it says the association has the right to repurchase your unit prior to sale to a third party, the law says that is presumptively void. And the reason for that is it was used historically as a basis for racial discrimination. And the law trumps what your governing documents say. Since I came in late, possible to have a video sent to me? Oh, sure, Al. I think we are. Yep, we're recording this, so sure. If you use Carl, I missed it. I'll try it again if it came back up. Richard says, may you revisit the New Jersey Department of Health pool use measures. So Mike Palulak was on earlier with us talking about the pool COVID restrictions. And what Mike said is basically a week or so ago, the Department of Health said that there are no COVID restrictions, COVID specific restrictions on pool usage this summer. However, all the pool health and safety rules and regulations still apply, which for those of you who are running pools know that there are still a whole bunch of rules and regulations with respect to that. Carl came back and said, if you use a third-party voting company, do you need to have all residents view the count? In my opinion, yes. Even if you use a third-party voting company, you would still have residents view the count. The question is, what does that mean, Carl, when everything is compiled electronically? And the way we've done it is really the count is just delivered and announced and shown during the open meeting so that people see the count. The count itself is automatic, but we still do have all residents able to view the count. It's a little kind of counterintuitive because the count is almost instant, but that's a good question, Carl. That being said, it's 4:51 on Friday night. I did not bring a drink with me tonight, so I am going to have a drink, and I hope all you do too. So go home, have a wonderful weekend. It's great seeing everybody, and I will see you next month. Thanks again. Good to see you. Bye-bye.